We are live. Hello, critical thinkers. Hello, hello, hello. Good evening for everyone with us on the chat, on the live stream. Thank you for coming. I am Fred. First and foremost, before I get into the news of today, the civil lawsuit filed back in 2020, I have to give everyone a big thanks for supporting the channel. The number of subscribers has grown significantly since the start of the year. So I want to thank you for subscribing. Thank you for watching. Thank you for liking. Thank you for your comments. And thank you for the overall support. I really, truly appreciate it. I never would have expected, covering this content would generate this much interest. And again, I'm hoping to bring this content to the masses. So thank you for everyone who's supporting. I appreciate that big time. So today's purpose is to go over the civil lawsuit filed back in 2020 with 5 women in New York State correctional facilities who were claiming that they were SA'd, assaulted. Okay. YouTube is very sensitive in terms of the language, in terms of saying certain keywords, so that they were violated. So I do want to cover that today. Before I cover that, I do want to go into an article by the Freelance News. I thought it was a great article. I definitely want to go over that before we go over the big stuff. Before we do the heavy lifting, let's go through the Freelance News. But if you're tuning in now, if you can just do me a favor in the chat and just put the city and state that you're watching from, that would be greatly appreciated. So what I'll do now is I'm going to pull up the freelance news article by JB Nicholas. Okay. And this article is, give me one sec. Oh, sorry. All right, give me one sec, people. We got some technical difficulties here, but we will fix this in a heartbeat. Okay, here we go. Okay. The freelance, LETITIA James doxes prison guards as strike turns nasty. Escalating crisis in New York prisons. We have this meme here. I'm going to get you and your co-workers too. Unleash the memes. Governor Kathy Hochul depicted as the Wicked Witch in memes circulated on social media by New York striking prison guards. New York has started doxing correction officers allegedly taking part in a wildcat strike against the state prison system. 25 guards had their home addresses published on the internet by State Attorney General LETITIA James on Wednesday, the 10th day of a strike that started at the Collins and Elmira correctional facilities on February 17th. Now we know that this wildcat strike has almost hit every single prison in New York State. I believe there might be 3 exceptions to that, 3 prisons who are not officially participating. Back to the article. The freelance broke the story exclusively. By last Wednesday night, guards at all but 2 of New York's 42 prisons were on strike. I stand corrected, it's 2. Last Thursday, Governor Hochul deployed the National Guard to replace strikers. Some were sleeping in cells. Quote, we have more than 6,500 National Guard members on duty for this mission that are actively being deployed to correctional facilities. Matt Januzinski, Governor Kathy Hochul's upstate press secretary, told the freelance on Wednesday. 90% or about 9 out of 10 correction workers and sergeants are illegally on strike, Jasinski added. Wow, I didn't realize the number was this large. So 90%, 9 out of 10 correctional officers and sergeants are illegally on strike. I mean, I can't imagine the impact it's having on the facility itself. and the impact it's having on inmates. Let's continue with the article. Strikes by all public employees are illegal under New York's Taylor law. Under the Taylor law, striking guards face automatic loss of 2 days' pay for every day on strike. Now, whether these correctional officers that are striking are going to face this consequence, I would bet my pinky toe that they won't face these consequences. I could be wrong. The strikes started the same week. 6 New York State correction officers were charged with murder for beating and choking Robert Brooks to death at the Marcy Correctional Facility on December 9th. Three more, um, three more were charged with manslaughter. 2 were charged with attempting to cover it up. 3 more pled guilty to unspecified charges and are cooperating with investigators. Sorry, with prosecutors. A list of demands was released by the guards who started the strike at Collins. Now, there's one thing I want to mention that there was a video I did, believe it was 2 days ago, in reference to correctional officers who were having a quote unquote info session. I believe it was Riverview Correctional Facility, and they stated they do not want to wear body cam. So I thought that was pretty fascinating that they don't want to wear body cams. And let's see if that's mentioned in this article at all. A list of demands was released by the guards who started the strike at Collins. First is repeal of the HALT Act, which restricts prison officials' power to impose long-term solitary confinement as discipline. According to the striking guards, without the ability to impose long-term solitary confinement, inmates face no meaningful punishment for misconduct. This has caused assaults on guards and other prisoners to increase, they say. So do me a favor, if you believe that the HALT Act has caused more violence in New York State correctional facilities, put that in the chat. If you feel that it hasn't caused more violence, put that in the chat as well. I want to get your feedback on this. The agency that manages the prison system is called the Department of Corrections and Community Supervision, or DOCS. DOCS and Governor Kathy Hochul appeared to grant the guards core demands last Friday, but they didn't trust her, so the strike continued. So I'm going to bring myself up real quick. So I found this very interesting, and for me, this seems very disingenuous on the part of the correction officers who were striking. Kathy Hochul went ahead and gave in to the core demands that you were asking for, and in turn, you continue to strike. Um, in essence, you're continuing to put people in harm's way, including the correctional officers that have stayed behind to do their jobs. A mediator, back to the article, a mediator has been facilitating negotiations between the two sides since Monday. So far, without, oh, I'm sorry, I didn't bring it up. Here we go. A mediator has been facilitating negotiations between the two sides since Monday, so far without a breakthrough. And this is an image here. We see striking New York prison guards from the Governor Correctional Facility protesting beside the area's main road on February 25th. Photo credit J.B. Nicholas. On Tuesday, Governor Hochul delivered a stern message to the striking guards. This must end immediately, she said. The illegal actions being taken by a number of individuals is putting the entire state at risk. If you are striking, she added, you are AWOL. You no longer secure the right to haven health benefits from the state. That goes away. Finally, she added, strikers should think of the legal fees they might face because this is not sanctioned by the union. They will not pay for this. While Governor Hochul was speaking, The angry wives of striking guards were visiting the offices of Senator Julia Salazar, who they hold responsible for the HALT Act. While video of the visit has not yet been made public, whatever happened prompted Senator Salazar to issue a statement on X, and this is her statement. To the wives of correction officers who decided to come to the Capitol today, screaming at my staff and refusing to leave our office to allow scheduled meetings with other advocates to resume. HALT is the law. Long-term solitary confinement is torture, and we don't want it in New York. So that was the official statement on X from Julia Salazar responding to the wives of the correction officers. Meanwhile, in Buffalo, State Attorney General LETITIA James sued the union and 333 named guards for striking illegally under the Taylor Law. State Supreme Court Justice Dennis E. Ward granted James' request for a temporary restraining order and directed the guards to return to work on February 19th. The order had zero effect. So we see an order coming out from Governor Hochul, and the correctional officers are continuing to illegally strike here. I'm going to pull up a comment. We have BJ Webb's. Incarcerated individuals I have spoken to agree the HALT Act does allow the gang members mostly to just do what they want because there really isn't much punishment being there. Much punishment being there is not any solitary confinement, much at all. So that's an interesting comment. I am not, to be honest with you, I'm not too versed on HALT. I'm not too versed on the effects of solitary confinement on individuals. What I will say is that in a previous stream, I had a YouTuber by the name of Conservative Felon who stated that we need solitary confinement for longer periods of time because you will have people who will act out and who will not behave unless they have a longer than 2 weeks. I'm paraphrasing, so that's a good point, BJ Webbs. Good point. Let's go back to the article. Before the court order can be enforced, it has to be served on the defendants. An assistant attorney general in James' office served 25 guards and filed an affirmation in the court record, so swearing on Wednesday. In this document that contains the names and addresses of 25 correctional officers, former State Attorney General Dennis Vacco is defending the guards against James' lawsuit. He did not immediately respond to an emailed request for comment. While not defending the doxing, Docs spokesperson Thomas Maley told the Freelance that the longer this illegal strike continues, the greater the risk becomes to the stability of these facilities and for the people inside them. It is imperative, Maley added, that this unlawful job action come to an end without further delay. And that's the end of the article. We have BJ Webb saying the cameras are very much needed. I agree 1,000%. These cameras are needed, and I'm shocked that correctional officers are talking about not wanting to have body-worn cameras. It's very shady. Okay. I am going to jump into the the um, the court filing back in 2020. Now, one thing that has to be said about this court filing is that as now there's a sixth plaintiff. So you have a Jane Stone number 6 who was added some time ago. You also have defendants who were not named in this initial complaint who were eventually named. My understanding as of now is that this case is ongoing. As many of you know or may not know, when you file a civil case and you sue corrections, you sue the state or any other entity, sometimes it can take years before going to trial. It takes years. So that's what we're seeing in this case. This was initially filed in 2020, in February 14th, 2020. So we have another comment from BJ Webbs. I don't feel it should be more than 30 days, but there is more inmate on inmate attacks. I feel lock is sock is one way. Lock and sock is one way. Okay, got you. Okay. I'm gonna jump into the article. I'm sorry, into the court filing now. And what I'm gonna do is I'm gonna put a link in the oh, by the way, before I put in the link to come up in chat for anyone who wants to do this later, I put a direct link um, to the freelance article, the freelance news article, and then I also put a link here to the initial court filing for those of you who want to be a legal nerd and read this on your own. By all means, you have that at your disposal. Okay, I'm going to go ahead and share this document with you. Okay, so we'll start from here. This was filed February 14th, 2020 in the Southern District of New York. Initially, you'll see here there's five plaintiffs, James Stone 1 through 5. It is possible for victims of SA to remain anonymous in their initial complaints. At some time in the future, that's going to have to be disclosed. I'm assuming docs and all the defendants and their legal representation already know who James Stone 1 through 5 and 1 through 6 are at this point because they're in the discovery phase. So let's take a look at who's being sued. We have Anthony Annucci. For those of you who don't know, he was the previous acting commissioner of the New York State Department of Corrections and Community Supervision. Next up, named in the civil suit, is Jason Effman, Associate Commissioner of PREA and PREA Coordinator of New York State Department of Corrections and Community Supervision. Next up, we have Sabrina Kaplan, who's the superintendent of Bedford Hills Correctional Facility. So one thing that you'll see is that the head of DOCS at the time was named, along with the heads of the individual prisons are also named. Next up, we have Brian Kubik, superintendent of Lakeview Shock Incarceration Correctional Facility. We have Tanya Mitchell-Void, superintendent of Teutonic Correctional Facility. We have Susan Squires, superintendent of Albion Correctional Facility. Now we have actual correction officers being named. The first one named in the civil lawsuit is James Castangwe. So just to give you some information about this gentleman is that, and I'm going to pull this up. I'll pull up the article to share with you. Okay, hold on. Okay, so this correctional officer, James Costanway, this is an update on what happened to him. Albion CO who pled guilty to sex crimes found dead before sentencing. So this article here, I'm not going to read it. I just wanted to bring forth to you that Um, this officer has since been deceased, and because he was deceased the day before his sentencing, he was not sentenced, but he was going to be sentenced to 6 months in jail. I'll go back to the court filing. Oh, okay. Next up, David Stupnick, correction officer at Albion Correctional Facility. So there's also an article on him. I'm not going to pull that up, but to make a long story short, he pled guilty, believe it was to rape, and he was sentenced to 6 months in jail. Let me just confirm that here. Yes, that's correct. He was sentenced to he was sentenced to 6 months, and he was placed on 10 years of probation, and he has to register as a sex offender. Okay. Here we have FNU, which stands for, I believe it's first name unknown, Guzman, correction officer at Bedford Hills Correctional Facility. FNU Page, correction officer at Bedford Hills Correctional Facility. Rasheen Smalls, correction officer at Bedford Hills Correctional Facility. Matthew Antolini, correctional officer at Lakeview Shock Incarceration Correctional Facility. James Beam, correction officer at Lakeview Shock Incarceration Correctional Facility. You have Alexander Vasquez, another correctional officer. You have Nancy Lopez, another CO. Kefion Lovelace. You have another CO, Pedro Norde from Teutonic. And then also, what you also have here named is the Office of Special Investigation. Two investigators were also named as well. So I thought that was interesting. So let's jump into what the actual court filing is saying. Plaintiffs Jane Stone, number one, number two, number three, number four, number five, by and through their attorneys, the law office of Zachary Margolis Ahunuma, and the law offices of Daniel A. McGinnis, PC, and for their complaint hereby allege as follows. Now here's the main meat and potatoes of the complaint. Here's the preliminary statement. This is a civil rights action brought under 42 USC 1983 against officials of New York State Department of Corrections and Community Supervision, DOCS, who violated the rights of 5 female inmates by sexually abusing them and acting with deliberate indifference to allow that abuse. DOCS officials and staff knew of the imminent threat of sexual assault, Jane Stone, number one, number two, number three, number four, number five, and deliberately failed to protect them. So this first paragraph, number one, is basically saying that the Department of Corrections uh, knew about the assaults, and they failed to protect these female incarcerated they failed to protect these female incarcerated individuals. Let's go to number two. So from 2015 to 2019, DOCS housed approximately 2,500 female inmates, around 5% of the total inmate population, in 6 facilities throughout the state. These women were guarded by male officers who routinely engaged in illegal sexual activity with individual victim inmates over long periods of time. Under the New York penal law, an inmate can never consent to sexual activity with an officer. See New York Penal Law 130.05. Nonetheless, DOCS supervisors cultivated a culture that allowed male staff to prey on female inmates to satisfy their sexual desires. Male staff were barely supervised and left alone with women under their control for long periods of time in unmonitored areas of the prisons. So I just want to stop it there real quick. One thing that we learned from the Robert Brooks murder is that the infirmary was an unmonitored area of the prison. My assumption is when they say unmonitored area, meaning that there's no cameras available to capture what's going on. I'm going to go back to the article. They had a system of warning each other if a supervisor was approaching and created a climate of fear and intimidation against any woman who complained about sexual attention from an officer. Um, so this is something I've heard. I can't tell you how many times I've heard this in terms of female incarcerated individuals who have complained and they have faced retaliation. There are a couple of YouTubers, formerly incarcerated females who talk about being harassed by male correctional officers. So this seems to be a common thing. Rather than investigate officer sexual abuse of female inmates in good faith, DOCS investigators blame the victims and coerce them into making statements, threatening punishment against those who chose to remain silent, and discrediting many of those who spoke up. As rapes and sexual assaults of female inmates continued with alarming frequency, the defendants covered up the assaults by giving lip service to official policies and disciplining individual staff members. Only when their sexual abuse of inmates became too egregious and notorious to ignore. So this seems to be something similar to Robert Brooks, right? This was the first time that a murder by correctional officers were captured on camera. Now you cannot ignore it. Now it's thrust into the spotlight. Whether there'll be justice for the Brooks family or not, I don't know. I truly hope so. But now it's warranted so much attention. So this is what this court filing is saying, is that when what happened was so egregious that it was just there was no way of ignoring it, which what they're saying was the norm. Okay. The multiple rapes and sexual assaults of these five plaintiffs and others described in this complaint could have been prevented. DOCS officials included both administrators and guards knew of the danger facing female inmates. They knew that multiple confirmed rapes had occurred in their facilities. They knew individual inmates were complaining of rapes that were unsubstantiated because the victims were routinely and unfairly discredited based solely on their status as inmates. They knew that guards were grooming inmates for sexual contact and coercive romantic relationships over long periods of time. In some cases, they knew of and tolerated blatantly inappropriate relationships between officers and inmates. They knew substantiated incidents of sexual abuse were 10 times higher in DOC's female facilities than male facilities. They knew the policies that needed to be corrected and how to fix their broken culture. And to this day, unfortunately, DOCS has not fixed their broken culture. The supervisory defendants named in this complaint nonetheless chose not to act, allowing these rapes and sexual assaults to occur and continue. Jane Stone 1 through 5 now bring suit under the Eighth Amendment to the United States Constitution, 42 U.S.C. 1983, and New York common law to recover damages for the harm caused by their sexual abuse at the hands of New York prison officials. Jurisdiction and venue, subject matter jurisdiction over the federal constitutional and statutory claims and is proper in this court pursuant to 28 U.S.C. 1331. The court has jurisdiction to order nominal, compensatory, and punitive damages attorney's fees, and injunctive and declaratory relief pursuant to 28 U.S.C. 2201 and 42 U.S.C. 1983 and 1988. So this piece of the claim I might just skip over. It's just making a claim that the court that they're filing this lawsuit in is the proper court. This is the proper venue. It's the proper jurisdiction. So this just gives more proof that it's the proper jurisdiction, citing the correctional facilities and the counties that they're located in. Okay, so let's jump into the plaintiffs. 15 plaintiffs: Jane Stone 1, 2, 3, 4, and 5 were at all relevant times female inmates under the direct control and supervision of DOCS officials. Plaintiff Jane Stone 1 is presently in DOCS custody, housed at Titanic in Bedford Hills, New York. During the relevant time periods, Jane Stone 1 was housed at Albion Correctional Facility and Titanic. Plaintiff Jane Stone 2 is presently incarcerated at Titanic. And by the way, just to remind everyone, this court filing was from February of 2020. So it's very possible all of the complainants are out of prison, maybe not. I'll attempt to get an update at a later time. Number 18, plaintiff Jane Stone 3 is no longer in custody and now resides in Binghamton, New York. During the relevant time periods, Jane Stone number 3 was housed at Taconic, pardon me. Plaintiff Jane Stone 4 is no longer in custody and now resides in Massapequa, New York. During the relevant time periods, Jane Stone 4 was housed at Lakeview and Taconic. Plaintiff Jane Stone number 5 is no longer in custody and now resides in Constantinople, New York. During the relevant time periods, Jane Stone number 5 was housed at Bedford Hills Correctional Facility, Albion Correctional Facility, and Taconic. The defendants. Defendant Anthony J. Annucci. Commissioner Annucci was at all times the acting commissioner of DOCS. Commissioner Annucci is sued herein in his individual capacity. Defendant Jason Effman was at all relevant times associate commissioner of the prison, of the associate commissioner of and Prison Rape Elimination Act coordinator for DOCS. Effman is sued herein in his individual capacity. Defendant Sabina Kaplan was at all relevant times the superintendent of Bedford Hills Correctional Facility, is sued in her individual capacity. Defendant Susan Squires, Superintendent Squires, was at all relevant times the superintendent of Albion Correctional Facility. Squires is sued in her individual capacity. Defendant Brian Kubik was at all relevant times the superintendent of Lakeview. Kubik is sued in his individual capacity. Tanya Mitchell Void was at all relevant times superintendent of Taconic. Superintendent Mitchell Void is sued in her individual capacity. Defendants James W. Castonguay and David Stupnick were at all relevant times correctional officers at Albion Correctional Facility. They are sued in their individual capacities. Now, for those of you who are joining us a little bit late, you might have missed James W. Castonguay he deceased the day before his sentencing. Continuing on, defendant Rasheen Smalls, Naresh Darshan, FNU Page, which stands for first name unknown, and FNU Guzman, CO Guzman, were at all relevant times correctional officers at Bedford Hills Correctional Facility. They were sued in their individual capacities. Defendants James Beam, Matthew Antoli, Alexander Vasquez were at all relevant times correctional officers at Lakeview. They are being sued in their individual capacities. Defendants Pedro Norde, Nancy Lopez, Kefion Lovelace were at all times correctional officers at Taconic. They are sued in their individual capacities. Investigator number 1 and investigator number 2 are pseudonyms for individuals whose names are unknown that were at all relevant times investigators at DOC's Office of Special Investigations. So those are all the defendants named. Let's go into the factual allegations. In fact, before we move on to the article, I want to go over a couple of comments here in the chat. We have Lightbringer saying they can still put in solitary for up to a year. Okay. Lightbringer also said, I can tell you from personal experience, it's called R or U. It's a program when you have to meet satisfactions for release into general population. Absolutely no violence or start over. Lightbringer again with another comment. They are withholding information. It's the same thing they do on the inside. Just like they don't mention how the officers have been writing illegitimate assaults on staff tickets on inmates as revenge. I've heard that before, Lightbringer. Since the HALT Act was implemented. And Lightbringer says, thank you for bringing light to this issue. Lightbringer, thank you for coming on. I appreciate it big time. Back to the article. Factual allegations, general allegations regarding the treatment of women prisoners in New York State. Number 32, DOCS operates 6 prisons across New York State that house women who have been convicted of crimes. Bedford Hills Correctional Facility is a high-security, all-female facility with a total of 926 beds and, as of October 2018, a population of 760 women. Taconic is a medium-security, all-female facility, capacity of 379, and a population of 329 as of October 2018. Albion Correctional Facility is a medium security, all-female prison, capacity of 1,100, population of 1083 as of April 2017. Lakeview, sometimes referred to as Lakeview Shock, is a special boot camp or shock incarceration program that is mixed gender. It housed 105 female inmates as of January 1st, 2018. Lakeview inmates agree to go through a rigorous physical and educational training program that involves, among other things, humiliation at the hands of staff, who are known as drill instructors. If an inmate then successfully completes the program, she can benefit from a reduction in her sentence. As described in further detail, women at these facilities are routinely guarded by men working alone, including during overnight shifts in women housing unit. Now, this is something I never understood. Men working as COs in correctional facilities. Is it that the job of a CO, even though it's in a female facility, that you have females who don't want to do the job? Because what I would think is that you would want as many female correctional officers as possible working in the female facilities. If any of you have any insight on why there are a lot of men, I'm assuming there are more male COs and female COs and female correctional facilities, feel free to chime in on the chat and let me know. Okay, let's go back. As described in further detail below, women at these facilities are routinely guarded by men working alone, including during overnight shifts in the women's housing units. As a general matter, Inmates are required to follow directions or verbal commands given by correction officers. A female inmate who does not obey a direct order by a male correction officer can be written up or subject to discipline, which can include solitary confinement, loss of phone privileges, loss of family visits, or loss of commissary. So you're a female incarcerated individual, you have a lot to lose. Correction officers have a lot of power. Commissary refers to a financial account that inmates are permitted to use to buy basic items in prison, such as soap, feminine hygiene products, and canned foods. Money is placed in an inmate's commissary account either by outside family or friends or through prison employment. In DOCS facilities, inmates and guards refer to the outdoor recreation space where inmates can congregate as the yard. Many yards in DOCS facilities do not have surveillance cameras. Okay, I'm surprised by that as well. In DOCS facilities, the bubble refers to a glass enclosed or open area, usually near the entrance to a particular prison unit, where an officer in charge of the unit sits. In many cases, an officer in the bubble can electronically control the opening and closing of cell doors. In DOCS facilities, the count refers to a period of time during the day when all movement within the prison is stopped so that staff can count the number of inmates to ensure that all are accounted for. Once the count clears, normal movement and activity in the prison can resume. Grooming is a term used by social scientists to refer to the a, uh, process by which a person intent on engaging in illegal sexual activity, such as with a child or with an inmate, gains trust from a vulnerable victim in order to gain sexual access to the victim without the victim revealing the sexual contact to someone who might prevent it. Male correction officers intent on engaging in sexual contact with female inmates frequently groom their victims by spending time speaking to them, allowing them to break seemingly um, um, arbitrary or minor prison rules, and providing them material gifts that make them more comfortable in prison, which can range from soap to alcohol or illegal drugs. Female inmates are sometimes temporarily deceived into believing that such contact is consistent with a normal romantic relationship when it is actually a ploy to permit prison staff to engage in illegal sexual activity. The Prison Rape Elimination Act, PREA, is a 2003 federal law aimed at preventing rape and sexual abuse at prisons. Detailed regulations are in place pursuant to PREA, and PREA reports are generated annually. A PREA complaint refers to a complaint regarding sexual misconduct inside a prison. The Office of Special Investigations is a unit within DOCS overseen by Commissioner Annucci and Commissioner Effman that has responsibility for, among other things, investigating allegations of sexual assault. The PREA hotline is a special phone number that inmates may use to make complaints relating to sexual abuse. By the way, if you haven't already, if you can do me a favor and hit the like button, it would be greatly appreciated. It helps with the algorithm. Let me continue with the article. Now we go to the specific sexual assaults of plaintiffs by DOCS correction officers. A. Officer Jason Castangue orally, vaginally, and anally raped Jane Stone number 1 in the laundry room at Albion Correctional Facility after raping another inmate. On May 12, 2019, Jane Stone was housed in the, I believe that says I-1 dorm building at Albion Correctional Facility. The dorm consists of cubes or bedding units with walls that do not go all the way up to the ceiling. At approximately 10:45 p.m., Jane Stone returned from Ramadan services and took a shower. CO Castengui, whom Jane Stone had never met before, entered the shower and looked at Jane Stone, who was nude. There was no emergency or other legitimate reason for CO Castengui to be in the shower area where Jane Stone #1 was unclothed. CO Castengui did not announce his entrance or give Jane Stone 1 any time to cover up. CO Castengui asked Jane Stone what she was doing. Jane Stone #1 stated that she was showering. CO Castengui told Jane Stone that it was about to be the count and for her to hurry. He then left the shower area. CO Castengui was wearing a body camera throughout the interaction. Interesting. Excuse me. Jane Stone #1 observed that the body camera was turned off because she knew the red light, which indicated that recording was not on. Upon information and belief, there were no other officers assigned to the unit at that time. No other officers were present in the unit at that time. Jane Stone #1 left the shower and immediately reported the incident to another inmate. Jane Stone #1 did not report the incident to prison officials because she was afraid of retaliation from staff, including other officers. Later that night, throughout the overnight shift, CO Castengui walked around the dorm, pausing outside of Jane Stone 1's cube multiple times. At some point that night, CO Castengui walked into Jane Stone 1's cube. Once in the cube, CO Castengui pulled out his penis. CO Castengui pushed his penis toward Jane Stone's head, instructing Jane Stone to perform oral sex on him. CO Castengui then put his penis in Jane Stone's mouth. CO Castengui turned Jane Stone's #1 around on her bed and vaginally penetrated her from behind with his penis. CO Castengui told Jane Stone #1 to get dressed and go to the laundry room. Once in the laundry room, CO Castengui entered the laundry room and, using force, orally, vaginally, and anally raped Jane Stone #2. CO Castengui did not use a condom and said, "You are not going to tell anyone, right?" CO Castengui then shoved his penis into Jane Stone's mouth and ejaculated. Once CO Castengui left the laundry room, Jane Stone #1 spit the ejaculate into a sock. Jane Stone #1 called the PREA hotline to report the incident at her first opportunity. No one answered the PREA hotline until after 8 a.m. later that day. So that's pretty shocking that this occurred. I mean, I really don't have any words to say about this. I, yeah, I mean, this speaks for itself. So no one answered the PREA hotline until 8 a.m. later that day. The watch commander, who was male, ordered Jane Stone to come to the Sally Port and ask about these accusations. Jane Stone #1 refused to answer questions about her PREA complaint in a public setting. The watch commander took Jane Stone to a private office and again asked about the accusations. Jane Stone #1 told him that she had CO Constangui's sperm. So she kept the sperm. Around 2:30 p.m., Jane Stone was transferred to a hospital for a rape kit. Before she was transferred, Jane Stone was held at the medical unit at Albion Correctional Facility, where an unidentified correctional officer approached her and called her a liar. Jane Stone number 1 provided the sock containing the ejaculate to investigators from OSI. When Jane Stone number 1 returned to her unit, the other inmates told her that they knew about the incident. In September 2019, CO Castingway was charged with criminal sexual act in the third degree, official misconduct, and rape in the third degree for his sexual assault on Jane Stone number 1. Upon information and belief, CO Castingway had raped another female inmate prior to his rape of Jane Stone number 1. So this is alleging that he had raped another female inmate. I'm gonna jump to a comment from BJ Webbs. Yes, an officer did this recently at Fishkill. He is abusive and works with gang members. Shaking my head. Okay. Let's proceed. As a result of the rape, Jane Stone number 1 suffers from depression and post-traumatic stress disorder and has been medicated by a mental health specialist to treat those conditions. At Albion Correctional Facility, David Stupnik engaged in illegal sexual contact with Jane Stone number 2 for almost 2 years, including at least 4 more times after DOXES investigators learned of the abuse. Jane Stone number 2 first met CO Stupnik in or about June 2017 while she was living in the L2 dorm at Albion Correctional Facility. CO Sputnik would go out of his way to speak to Jane Stone number 2, even searching for her in the chapel. In or about August 2017, Jane Stone number 2 was transferred to the I-1 dorm building. In that time frame, the I-1 dorm building was one of the units in which CO Sputnik regularly worked. In that time frame, CO Sputnik worked the 7 a.m. to 3 p.m. shift. CO Sputnik was the only officer assigned to the unit during his shift. The I-1 dorm housed 60 women in bunk beds and individual cubes. After Jane Stone 2 was moved to I-1 in August 2017, CO Sputnik spent long periods of time during the day engaging Jane Stone 2 in personal conversations. During CO Sputnik's shift, correction officers on other units would routinely radio ahead to warn other correctional officers when supervisory rounds were about to occur. During his conversations with Jane Stone 2, CO Stupnik did not appear worried that he would be caught speaking to Jane Stone number 2 for extended periods. In or about November 2017, Jane Stone number 2 was transferred to the J2 dorm. CO Stupnik worked in the J1 dorm twice a week during the 3 p.m. to 11 p.m. shift. The J1 and J2 dorms were connected by a locked door that the correctional officers could access with a key. After Jane Stone 2 was transferred, CO Stupnik continued to meet with Jane Stone number 2 and spent long periods of time speaking with her at the officer's desk. In or about December 2017, CO Stupnik kissed Jane Stone number 2 on the lips inside another inmate's cube in the J1 dorm. In or about January 2018, Jane Stone number 2 was transferred to the mess hall dorm. One night, shortly after Jane Stone number 2 was moved, CO Stupnik swapped bids to work in her unit. CO Stupnik directed Jane Stone number 2 to lay on the bed. While Jane Stone number 2 was on the bed, CO Stupnik kissed her. He then slid his hand into her shorts and digitally penetrated her vagina. In or about April 2018, Jane Stone was transferred to the L1 dorm. At that time, CO Stupnik began swapping his bids in order to work at the L1 dorm during the 3 p.m. to 11 p.m. shift. Every time CO Stupnik swapped to L1, he would take Jane Stone 2 to a cube and digitally penetrate her vagina. Usually, CO Stupnik would use the corner cube of a different inmate. CO Stupnik sent Jane Stone number 2 intimate letters that were often sexual in nature. In or about August 2018, Jane Stone number 2 was moved to the J1 dorm where CO Stupnik worked. CO Stupnik worked at the J1 dorm post twice a week from 3 p.m. to 11 p.m. CO Stupnik engaged in illegal sexual conduct with Jane Stone number 2 in a cube or on the stairs leading up to the officer's desk every time he worked at J1 from in or about July 2018 until in or about January 2019. In or about August 2018, Jane Stone 2's cube was searched while she was out in the yard. Jane Stone number 2 learned about the search from several inmates who told Jane Stone number 2 that OSI had come and searched her cube. Jane Stone number 2 was never told by prison officials why her cell was searched. CO Stupnik told Jane Stone number 2 that other correctional officers were advising him to give up his bid or to transfer to another facility because doc staff were talking about their relationship. In or about December 2018, CO Stupnik began meeting Jane Stone 2's sister outside of the facility. CO Stupnik gave Jane Stone 2's sister approximately $100 a week to put into Jane Stone 2's commissary account. CO Stupnik also smuggled cigarettes, nail polish, and makeup for Jane Stone 2 into the facility. CO Stupnik bought Jane Stone 2 a diamond heart-shaped necklace from K Jewelers. Wow. CO Stupnik smuggled the diamond necklace into the Albion Correctional Facility so that he can give it to Jane Stone number 2. Upon information and belief, OSI recovered the necklace. In January 2019, Jane Stone number 2 was transferred to the I2 dorm, the honor dorm, which is another one of CO Stupnik's regular posts. He worked the same 3 p.m. to 11 p.m. shift 2 days a week and continued to sexually abuse her every time he worked. February 2019, CO Stupnik entered Jane Stone number 2's cube each night and made Jane Stone perform oral sex on him. Later that month, another inmate in I2 dorm reported the relationship. 2 OSI investigators, Investigator 1 and Investigator 2, called her to the administrative building. The investigators asked Jane Stone 2 about her relationship with CO Stupnik. The investigators told Jane Stone 2 that she had to talk or they could charge her with felonies for receiving contraband. Jane Stone 2 refused to speak to the investigators. CO Stupnik was not removed. Jane Stone 2 returned to the dorm where CO Stupnik had her perform oral sex on him again, the same evening that she spoke to OSI investigators. Upon information and belief over the next few days, Investigator 1 and Investigator 2 called dozens of inmates to admin to ask about the relationship between CO Stupnik and Jane Stone 2. Upon information and belief, CO Stupnik abuse of Jane Stone 2 was corroborated through those interviews. For the next 2 weeks, CO Stupnik continued to work in the I2 dorm. CO Stupnik directed Jane Stone 2 to perform oral sex on him at least 3 more times. At the end of February 2019, Jane Stone 2 met with 2 OSI investigators, Investigator number 1 and a different OSI investigator. Investigator 1 and the other investigator asked her again about the relationship with CO Stupnik and told her that she had to talk or things would only get worse from here. Investigator 1 and the other investigator told Jane Stone 2 that someone had searched her cell and that they had DNA evidence. Investigator number 1 and the other investigator also told her they had dozens of statements from other inmates about the relationship. Jane Stone 2 feared that she would be punished for her own victimization. Jane Stone 2 wrote a statement denying their relationship. Later that day, Jane Stone 2 was moved to the A block dorm. Upon information and belief, CO Stupnik finished work that day and then was told he could not return to Albion Correctional Facility. At the beginning of March 2019, Jane Stone was transferred to Taconic. Upon information and belief, in May 2019, CO Stupnik wrote a full confession of his illegal sexual contact with Jane Stone 2 and of sexual contact with a separate inmate at Albion Correctional Facility, whom he also raped. CO Stupnik was criminally charged with 4 counts of second-degree abuse, 2 counts of third-degree criminal sex acts, and 2 counts of official misconduct for his illegal relationship with Jane Stone 2 and another inmate at Albion Correctional Facility. In or about July 2019, Jane Stone 2 provided a full statement about the relationship between herself and CO Stupnik. As a result of the abuse, Jane Stone 2 has become anxious, severely depressed, has trouble sleeping, and cannot trust others. Jane Stone 2 sought psychological or psychiatric treatment from DOXES for the symptoms of her sexual victimization. Jane Stone number 2 was sent to a DOXES treatment provider who falsely told her that she, quote unquote, looked fine. To date, Jane Stone 2 has not received any mental health treatment. Okay, so I think we'll stop here. For those of you who don't know, this court filing is 76 pages, so it's pretty long. So I'm not going to cover this all in one stream. I'll cover this over the course of multiple streams. Obviously, this is a very important civil suit that has been filed. 2 correction officers were charged, arrested, and found guilty. One passed the day before his sentencing, and the other served 6 months, also had to do 10 years of probation. So I do want to continue to cover this. This is pretty long. So what I will do is I'm going to end the stream here. Let me just remove this. I will end the stream here. Any more comments, any more clarifications? Anybody wants to come up and chat? I'm going to put in the link to the chat one more time, and I'll give it a few minutes. We have Clifton Ketchum from Norwich, New York. Thank you for watching. Thank you for coming in. I really appreciate it. Thank you so much. So, okay. Okay, so with that being said, I want to thank everyone who was on the chat. Again, I'm going to continue reading this court filing. It's very long. We got through 21 pages out of 76. So I do appreciate everyone who's been on. For me, this was an important court document to review, to go over. So thank you for staying on and listening. I appreciate it immensely. And as I say in all of my videos and live streams, if you found value in this video, please like the video, share the video, and if you feel that I've earned it, please subscribe to the channel. And if you have already, encourage someone else to subscribe. Again, when I started the live stream, I wanted to thank everyone for for showing me their support, for watching my videos, for subscribing. I've grown to about 600 and something subscribers. So I want to thank everyone for that. Let's keep pushing the news about Robert Brooks, about the injustices in the criminal justice system, specifically these correctional facilities that seem to be just a culture of chaos and a culture of corruption. We have to stop these abuses. So thank you for watching. Take care, and I will see you next time. Bye-bye.